Welcome everyone, Annick Koloko, Koloko Immigration Law, Visa Girl, Koloko Immigration Law. This week's video is about the I601 waiver. As you may remember, last week's video was relative to the I601A waiver that is actually necessary to cure unlawful presence in the United States. There are several types of waivers, and this is the second one in our series about this. As you are aware, there are several issues that can arise for people who are traveling to the United States. We cover the fact and also the instance where somebody will come to the United States unlawfully and enter without inspection, and obviously that person will not be able to adjust their status as they will have this particular issue. The I601 waiver also addresses similar issues, specifically what is called ground of inadmissibility. There are several reasons why somebody can find themselves facing several grounds. There are grounds of inadmissibility based on misrepresentation. The example that comes to mind is somebody who actually stated or provided an information to the United States Service, talking here about USCIS or CBP, knowing exactly that the statement that they actually advancing is patently false. We also have instances where the person has been convicted of a crime. This is something also where you will need an I601, you will need a waiver to cure these issues. And here, how does someone proceed? Number one, you have to demonstrate that you have what is called a qualifying relative. That is a very important requirement. A qualifying relative for this particular waiver will be a U.S. citizen spouse or a lawful permanent resident spouse, or either a U.S. citizen parent or a lawful permanent resident parent. You have to demonstrate first that the application we're talking here about, the I-130 petition, has been approved by USCIS. Once this petition has been approved, then the waiver can be submitted before USCIS. But the most important legal requirement here will be what is called extreme hardship. And this is actually something that is very confusing to some clients, because the extreme hardship is very specific and USCIS is looking for certain facts, and the burden of proof is actually on the applicant, in this case the immigrant. What does that mean by extreme hardship? Extreme hardship, number one, you have to remember that it's not extreme hardship to you, the immigrant, but extreme hardship to your qualifying relative, in this case the lawful permanent resident or either the U.S. citizen, spouse or parent. For example, if your qualifying relative is actually somebody who suffers of a serious illness, for example, let's say cancer, it can be argued that if the qualifying relative will have to follow you and relocate to your country of origin, this person may not be able to have the same treatment available to them, or obviously maybe not access to doctors that are maybe the same caliber, or either because they are not familiar with those new doctors, meaning basically that is a hardship to ask someone to uproot themselves and to start over in your country. You can also have some examples regarding professional consideration. In this case, the qualifying relative, for example, have a business that is located in the United States, and this business is actually quite successful, and you have family members that are depending on it, as far as living. If your qualifying relative has to uproot themselves and go with you to your country of origin, that will constitute a financial hardship as well. You can also have several cases regarding professional license, somebody who is a doctor, a lawyer, a nurse, and so on and so forth. You can see where this is going. Meaning it's quite interesting, if you believe that you need to file a waiver, it is more important than ever that you contact legal counsel. We do handle this type of case quite often, preparing affidavit, obviously to support, to demonstrate the hardship. This is something that is extremely important that you have to demonstrate to USCIS because they will want to have this issue. We submit also some report from professionals, whether it's a psychologist and so on and so forth, meaning there are a lot of evidence, a lot of affidavit that have to be submitted. Obviously, this is actually something that is very important. This is very technical, and I believe that you should be aware of that. And if you believe that this is something that you need help with, do not hesitate to contact our office, obviously. This is actually the end of our video. This is a subject that is quite technical and much more actually it's impossible to cover all of this in this video. If you believe that this video could be helpful to someone, do not hesitate to share. Please like our video if you believe this is something that you found interesting or useful. You can join also our Facebook page and just subscribe to our Facebook page or either our YouTube channel, Visa Girl. We're always glad to hear from you. If you have suggestions about any other subject that you would want us to address, please do not hesitate to let us know. If you believe that this is something that you would like to pursue forward, the best way to reach us is by email at info@kolokolaw.com or either on our Facebook page or by messenger as well. Until then, I wish you well, be safe, be well, goodbye.